If you're applying for an Australian partner visa in 2026, you are looking at an average processing time of 16 to 27 months just for the first stage. Think about that for a second. Your life, your relationship, and your future are essentially on hold for over 2 years. So this explainer is not about a casual application process you just breeze through on a Sunday afternoon. It's a high-stakes legal briefing. The rules have drastically tightened, the costs have skyrocketed, and your margin for error is virtually zero. You absolutely need to get this right the very first time.
So why exactly does it take 16 to 27 months for the 2025-2026 program year? Well, it really comes down to an immense backlog and the extraordinarily rigorous scrutiny every single application undergoes right now. The Department of Home Affairs meticulously investigates these files. That's potentially over 2 years of waiting in limbo, just for step 1 of the temporary stage. And remember, that timeline assumes your application is absolutely perfect from day 1. If it's not, you aren't just looking at agonizing delays, you're looking at a very expensive, life-altering rejection.
And speaking of expensive, let's talk about the financial reality. On July 1st, 2026, the Australian government hit applicants with a massive 25% fee increase. We went from an already steep $9,365 to a staggering $11,710. And here is the absolutely crucial point you've got to understand. This fee is paid up front, and it is strictly non-refundable. The department genuinely does not care if your refusal was due to a simple clerical error, a missing signature, or just a misunderstanding of the law. Once they make a decision to refuse your visa, that 11 grand is gone forever. Poof!
Section 1. Choosing your pathway. Onshore versus offshore. Okay, let's dive into this.
The very first decision you make is structurally the most important one. Which subclass are you actually applying for? It entirely depends on where you are physically located when you hit submit. Subclass 820 is the onshore pathway, meaning you are physically inside Australia when you lodge. Subclass 309 is the offshore pathway, meaning you're outside the country. Now, the massive advantage of the onshore 820 pathway is the bridging visa A. If you apply onshore while holding a valid substantive visa, you're granted this bridging visa. This is huge, guys. It allows you to remain lawfully in Australia with your partner during that grueling 16 to 27-month wait, and it typically comes with full work rights and access to Medicare. The offshore 309 pathway, it offers absolutely no bridging visa protection. You just have to wait outside Australia. However, applying onshore does open you up to the Section 48 bar, which we're going to touch on shortly.
Section 2. Strict eligibility, de facto versus married. Let's move to the rules.
It's entirely your responsibility to understand these strict legal requirements before you hand over that $11,710. A lot of applicants assume their relationship is genuine enough to just bypass the technicalities. That is a fatal mistake. The rules are incredibly rigid. If you are legally married to your Australian sponsor, there's no set waiting period to apply. You can literally lodge immediately after the wedding. But if you're applying as a de facto couple, the law requires exactly 12 continuous months of cohabitation immediately before you lodge the application. The department does not round up. Lodging your application at month 11 and 3 weeks is a guaranteed refusal. Actually, there's one massive tip here. Formally registering your relationship under state law can actually waive that strict 12-month cohabitation requirement. So if you're at month 10, registering your relationship could literally save your application, but you must have the certificate in hand before you apply.
So, how do you actually prove your relationship is genuine? Because being in love is simply not enough. With immigration fraud being so high, the government uses 4 specific categories to mathematically quantify a romantic relationship. It's kind of like a giant puzzle. The case officer doesn't know you. They only know what's written on the paper in front of them. You have to prove your relationship across these exact 4 pillars: financial aspects, the nature of your household, social aspects, and your long-term commitment to each other. If you ignore even one of these pillars, your whole application will just crumble.
What does that actually look like in practice? It means providing tangible, undeniable documents. You need to build a compelling narrative using evidence like joint bank accounts, shared lease agreements, and household bills in both names. Take the Form 888, for instance. This is a statutory declaration by an Australian citizen or permanent resident who can legally vouch for your relationship under oath. It is serious documentation. Case officers assess hard facts, not feelings. For example, a massive red flag for a case officer is seeing partners who claim to have lived together for years, yet they still just Venmo or bank transfer each other for groceries and rent instead of using a joint account. To the department, that signals a complete lack of true financial pooling.
Now here is a critical update for 2026.
The department has explicitly stated that applicants must continually refresh their file. Because the processing times are dragging on so long, you are now expected to update your relationship evidence every 6 to 12 months. Stale evidence at the permanent residency assessment stage is a massive hurdle. Imagine submitting a 12-month residential lease signed in early 2024. When the case officer finally opens your file in 2026 and sees that old lease without any updated documentation, it immediately triggers a red flag. They're going to question if the relationship is broken down and if you even still live together.
Section 3. Common refusal traps. Let's look at exactly where applicants waste their money.
Walk through these fatal pitfalls with me. First, the Section 48 bar. If you're in Australia and have ever had a visa refused or canceled, you might be legally barred from applying for another visa onshore. Do not lodge an 820 visa without checking this, or it's an instant refusal and you lose the fee. Second, requests for information, or RFIs. The department has instituted a brutally strict one-request-only rule. If they ask for a document, say an updated police check, and you miss the 28-day deadline, they will not send a follow-up email. They won't call you to check in. They will simply reject the visa based on the incomplete information they have. Third, as we discussed, failing to meet the full 12 months of de facto cohabitation before lodging. Just don't jump the gun. And finally, trap 4, letting your evidence go completely stale over that 2-year wait.
So I want to leave you with this provocative question. Is your application truly decision-ready? In 2026, the department expects a flawless, comprehensively documented file right from day one. If you're doing this yourself, you need to take a step back and honestly assess if your file can withstand the intense, unforgiving scrutiny of a case officer. Are you absolutely certain you've met every single requirement, or are you risking an $11,710 mistake? Take the time, get your evidence in perfect order, and make absolutely sure your pathway is legally sound before you ever hit submit.